Good afternoon. It's a pleasure to be with you all today. Thank you to the American Bar Association Rule of Law Initiative for this invitation. It's been a gorgeous experience being in this annual meeting. The role of lawyers during times of transition. As many of you know, Mexico is going through tough times. This undesired situation has been caused by a number of factors such as economic crisis, lack of education, poverty, corruption, drug cartels, and maybe the most important one, lack of values. As a legal profession, what are we doing to minimize this crisis? There are three main efforts that we are doing in order to achieve this goal. First, Bar Association membership. Today in Mexico, there is no legal obligation to become member of a bar association. A person may simply finish law school, get licensed, and is allowed to practice law in all fields. There are no state bar exams in order to practice law, and therefore it is common to see cases where people lose money, properties, and even their freedom because of legal malpractice. How to cope with this situation? Many think it could be done by having membership to a bar association be mandatory. By making bar membership mandatory, all lawyers in Mexico will have to comply with three main requirements. First, to abide by ethical principles. Second, to comply with continuing legal education standards. And three, to perform pro bono work. The three main bar associations in Mexico, including the Mexican Corporate Counsel Association, ANADE, got together and prepared a draft constitutional amendment aimed to require lawyers to become members of a bar association. They also drafted new regulations governing professions. Both documents were filed with the Senate. Soon, we will have a meeting with a group of senators in order to speed up this process. It is well known that many governments do not want lawyers to be organized and reasonably united. However, if this leads to a better legal profession in our country, it is a must to achieve this goal. Second main effort. The law profession in Mexico also collaborated with the federal government in preparing two bills. First, the Bill of Federal Law Against Corruption in Public Contracting Processes. This bill enacts the concept of intermediary, which includes advisors or consultants intervening in public contracting processes who act in the name, on behalf, or for the benefit of persons participating in such processes. During an investigation, the competent authority may require intermediaries to produce information and documentation linked to allegedly illegal activities. And the second bill is a bill of federal law for the prevention and identification of transaction with illegal resources and financing to terrorism. This bill enacts the concept of vulnerable activities. which includes professional activities in certain fields. Those who participate in this performance of vulnerable activities shall be required to, first, identify their clients and verify their identity. 2, gather information concerning the client's activity or occupation. And 3, to keep, protect, and safeguard information. Administrative and criminal liabilities may arise from violations to this law. These 2 bills have been approved already by the Senate and are currently being reviewed by the House of Representatives. And the 3 main efforts that the legal profession somehow is helping in order to minimize this complex crisis. This is a criminal field. As a result of an increase in the criminality rate a couple of years ago, an amendment to the criminal justice system in Mexico was put in place with some help from the legal profession. Such amendments included modifications to several constitutional provisions which establish that criminal procedures are to be conducted on an accusatory and oral basis with the intent to protect the rights of the victim. In general terms, the legal profession feels that there are some positive reforms, while some others will not achieve their intended goals at all. Negative aspects of the Mexican criminal justice system. Defendants have, from the beginning, the right to a public defender, while victims do not have access to legal counsel afforded by the state. In some cases, the victim will have to retain his own counsel. Defendants have the right to be prosecuted within a certain period of time, and if not sentenced, they must be released. Whereas the victim must necessarily wait for a resolution which may be appealed twice by the defendant. Defendants have the right to contest on constitutional grounds an arrest warrant or a judgment of conviction affirmed by the Court of Appeals. Notwithstanding, the victim cannot challenge a denial of an arrest warrant or an acquittal, which is later affirmed by the Court of Appeals. Now, public prosecutors may request preventive custody when other remedies are to be insufficient to ensure the appearance of the defendant, the proper course of an investigation, or the protection of the victim, the witnesses, or the community. However, the amendment does not make reference to the notion of release on bail, which was previously set forth by the Constitution. This failure creates inconsistencies with the need to guarantee restitution to the victim. However, there are important adequate amendments to the criminal justice system in Mexico. First, I would say that limiting preventive custody requests from public prosecutors is a remarkable step forward in regards to the presumption of innocence in Mexico. Now, the victim has the right to participate in criminal proceedings. This is consistent with the principle of equality of rights between the victim and the defendant. With the amendment, the public prosecutor shall ensure protection of victims, witnesses, and all individuals involved in the process. The judge shall monitor the implementation of this obligation. And this is a positive change, since it was necessary to extend such protection to scenarios other than minors who were required to confront the accused party. Today, the victim may appeal before the judiciary the failures from public prosecutors arising when investigating offenses, as well as its resolutions concerning the suspension of an investigation and non-prosecution, among others. This is innovative, since the decision to suspend an investigation had become a mechanism used by public prosecutors to stop processing a criminal investigation. Now, the victim has the right, in some cases, to file criminal action before the judiciary, which is a significant innovation to the Mexican criminal procedure, since the participation of public prosecutors is not longer required to begin a criminal proceeding, again, in certain cases. This amendment shall help to prevent certain improper actions from public prosecutors who fail to prosecute cases despite an offense has been made and the participation therein of the accused party is evidenced. As you all can see, Mexico is going through tough times. Lawyers in Mexico are now more united than ever and are cooperating as members of a relevant profession to overcome this situation. However, and as you heard at the beginning of my presentation, we face a complex crisis which brings up the question that I have heard so many times. Is Mexico ready and prepared to deal with this crisis and prevail? I am sure that with the help of everyone, including the ABA Rule of Law Initiative, I really certainly believe Mexico is ready. Thank you.